our speaker today, Miss Pam T. Toy. Hi, Miss Pam. So Miss Pam T. Toy is a trademark, the head of trademark department at Business IP. So she has a lot of experience in executing and prosecuting trademark cases in Vietnam, Laos, Cambodia, as well as Myanmar. Right. So she has established IP rights in the international and domestic clients portfolio in these countries, and she's also active in the enforcing against counterfeit activities in Vietnam and Myanmar, and also international cooperation activities. That's why we have this talk with Ms. Pam. Right. So without further ado, let us move on with Ms. Pam's talk. Ms. Pam, the floor is yours. Thank you.
Hello, everyone. Today I am going to talk about some trademark matter in Vietnam, Laos, and Cambodia.
Can you speak louder, Ms. Pam? Voice. Thank you.
Today I will talk about the topic remarkable issues and the difference in trademark practice in Laos, Cambodia, and Vietnam. Firstly, I would like to introduce about the filing a trademark application in 3 countries in comparison among these countries. In what is a trademark in Vietnam, Laos, and Cambodia? Where any difference between 3 countries? Firstly, I would like to talk about the definition of a trademark. Any visual sign that can serve to distinguish the goods or services of one party
Sorry,
from
Ms. Pam, can you
the
go
others.
full screen? Full screen.
Yeah,
Full
because
screen.
as a trademark, they may include letters, words, drawing, or image, including three-dimensional image or a combination thereof, and they may be presented in one or more colors.
Can you go full screen?
There is no difference about a trademark in Vietnam, Laos, and Cambodia. I would like to take a look about a series of trademarks in all 3 countries. Although there is not any regulation about a series of trademarks, but in practice, this kind of trademark is not accepted for protection in these countries. Now, all 3 countries, the 11-9 classification is adopted, and very different in 3 countries in adopting of this kind of the NICE classification. The purpose of the NICE classification in Vietnam is for filing a classification of goods and trademarks, for filing application, and calculation of official fee. But in Cambodia and Laos, the classification is for classification of goods or services only. This means that in Cambodia and Laos, the official fee is based on the number of class, not in the number of each item of goods or services.
Can you share full screen, Ms. Tui? Full screen. Yeah.
I have shared.
No, check the full screen.
Okay, our screen is. Do you see our screen?
Yeah, I see your screen, but it's not full screen. It's full screen. Ah, yes. Okay. Nice.
The next matter I will talk about is the POA in the filing a trademark in Laos, Cambodia and Vietnam. The POA in the Vietnam is only required to be signed by a legal representative. Meanwhile, in Laos and Cambodia, it is required to notarize by a notarized public. And in Vietnam, under the latest guardian, the signature should be signed by the president or general director or director. Meanwhile, in Laos and Cambodia, the POA is required to notarization. But in Cambodia, there is a specific paragraph to be inserted in the POA, and the notarization should be done in the applicant countries. In Vietnam, a general POA can be used for own IP matter, for example, trademark matter, design or patent matter, but in Cambodia is used for trademark matter only. This is because of there are two office, two different office. The POA in Vietnam is valid, is no time to limit, but in Laos and Cambodia, the POA is valid in 5 years.
What does it mean by 5 years? What happens after 5 years?
Yeah, so POA is valid in 5 years only, and then if the same applicant wish to file an application in Laos or Cambodia, they should be provided with refresh POA.
Oh, so every 5 years, the applicant has to provide new POA.
Yes.
Even though the trademark is active?
Yes.
Oh, I see.
In Vietnam, there is no time limit for a POA. This is different between 3 countries.
Okay, okay. Wow. Okay.
And in Vietnam, when you were filing an application, the application is not required to be state about the VN classification. This means that if the trademark contains the figure, it is not required to classify the VN. But in Cambodia, it should be classified in the application form before filing with the VIP. And Laos also is not required to be clarified under the Vienna classification. One more difference between in the filing the application in Vietnam, Laos, or Cambodia is the statement of this setting disclaimer in the application form. In particular, in Vietnam and Laos, is not required to stating any disclaimer of any element in the symbol of mark. But in Cambodia, the applicant should is recommended to state any disclaimer in the application form at the time of filing, in order to avoid any possible objection from VIP. In practice, in Laos recently, The DIP has been requesting a disclaimer on for element in the apply for the trademark which apply under the maritime system. But the national system, the DIP has not required this type of disclaimer. In Vietnam, although the disclaimer is not required at the time of filing, but the IPVN, the intellectual property of Vietnam, will be exempt, and then they will itself decide which elements should be disclaimed and list them in the notice of payment program. The next matter I will talk about is the limitation of the services in the application form. If in Vietnam, the official fee will be calculated based on not only the number of classes, but also the number of goods or services in each class. But in Laos and Cambodia, the official fee will be calculated based on the number of classes only. And if the for one trademark application, if you file in Vietnam, the fee may be expensive than the two countries if the trademark, if the application is registered for many items in each class. Since
so
it's
the most expensive country.
If there are many items in each class, since there is additional fee for each item in each class, as from the 7 items onward.
Oh wow!
Yeah. Meanwhile, in Laos and Cambodia, the official fees will be calculated based on the number of class only. Yeah. Regarding the types of the applications, in all Vietnam, Laos, and Cambodia, both multi-class application and single class application are acceptable. And almost 3 countries, both multi-class application or single class application has advantage or disadvantage. To clarify, I would like to note about some advantage of multi-classes application or single class application. The advantage of the multi-class application is also the disadvantage of the single class, and vice versa. For example, in respect of the multi-class application, there are many advantages. For example, it will be saving fees, both official fee and attorney fees, and simplifying management and save the resource of storage. But there are also disadvantages of multi-class application. For example, in case a trademark of multi application is partly refused for one or some classes, if in Vietnam it's possible to divide it into several applications, but in Laos and Cambodia it is not accepted for dividing the application into several applications. And then in respect of the multi-class application, it will take more time to exam than the single application. this is some advantage and or disadvantage to the applicant. Applicant could choose which kind of which kind of application should be filed at the time of filing.
So, Ms. Tui, which class, what type of goods and services do you get the most trademark applications over there?
From the class 1 to class 45 under the NICE agreement.
Yeah, so which class do you get many trademark over there?
Class 32.
32. I see. And what is that class?
No, our class 43 and class 35. The common class which we have registered for our client.
Okay. Food product and services, right?
The product mainly is food products and trading services.
Trading services.
Providing food and drinks.
Okay, I see.
Regarding the time frame of a trademark in Vietnam, Laos, and Cambodia, in Vietnam it takes about 12 to 16 months to obtain a certificate from the IPVN, but in practice it takes about 2 years to obtain a certificate from IPVN. In Vietnam, in order to obtain a certificate, it should be include 4 steps to exam, including formality examination. It will take about 1 month to obtain a decision on acceptance of formality. And then if the trademark is all required document is accepted by the IPVN, it will be published on the official gazette. And then the trademark will be under the substantive examination within about 6 months under the current law, but in practice it may be take about 2 years. And then if the trademark is the trademark meets all criteria of the protection, it will be accepted for protection. So the IPVN will issue a notice of payment of grant to invite the application to pay the granting fee, and after the application file the submitted pay the granting fees, the IPVN will be issued a certificate of trademark registration, and it will be published on the official gazette. The procedures in Laos and Cambodia is also similar, but the time frame there are different. In Laos, it takes about 10 to 12 months to obtain a certificate of trademark registration from the DIP, and in Cambodia, it takes about 6 to 7 months to obtain a certificate of trademark registration from the TIP. The difference I would like to emphasize the difference is that in Cambodia, after the trademark is accepted as to formality, it will be published on the online database rather than on the official gazette. Regarding the opposition procedure in Vietnam, any third party could file an opposition before the trademark is accepted for products, before the DIP, the EPIP, decision on granting a certificate. This means that there is no exact deadline to file an opposition in Vietnam, but in Laos there are 60 days as from the publication date for any third party who could wish to file a request for opposition in Laos, and this deadline is not extendable. The difference is that in Cambodia, an opposition could be filed in re or post grant. Although the law is under the law, the opposition is only filed after the trademark is registered. But in practice, both pre and post grant, any third party could file an opposition against a pending or registered trademark. So the deadline for filing an opposition in Cambodia is 90 days as from the publication date of the registered mark. But in practice, you could file at any time after the publication date after the formality is sufficiently and in order. This is the reason why we would like to tell about I would like to emphasize about the publication in Cambodia after the formality state. Although it's will published on the online database rather than the official gazette, but any third party could still file an opposition at this time. Do you have any questions about this matter?
No.
Oh, yeah. I will continue to talk about the non-use cancellation. In all three countries, Vietnam, Laos, and Cambodia, any third party could file a cancellation request against a trademark registration based on non-use in the period of 5 consecutive years. And in Vietnam, when you file a cancellation request based on non-use, it's required to file together with an initial evidence. Meanwhile, in Laos, there is not any regulation about this matter when filing a cancellation request. I would like to emphasize about the difference in Cambodia. In Cambodia, under the law, it's possible to file a cancellation based on non-use, but in practice, there are differences in practice and under the law. For example, introduce on and grant a solution based on non-use. And in case you find a cancellation request against a reserve our request to the use or non-use. This means that it's not feasible to find a cancellation request based on non-use.
Miss Tweet, your
due
screen
to the difference.
Miss Tweet, your screen is stopped. Can you share again? The line broke. Sorry. Your line broke. Your screen is stopped. Yeah.
Okay. This is the difference due to the difference between the law and practice about the cancellation trademark based on non-use and the cancellation on basis of non-use is not feasible in Cambodia. The reason is also differs from the maintenance of a registered mark. In Vietnam and Laos, there is not required to file any document to prove the actual use for trademark in these countries. But in Cambodia, it's required to file an affidavit of use or non-use in the period of the 5th and 6th years after the trademark is registered. If last year, when you filing an affidavit of use, is not required to submit together with the evidence, but now is required to, if you choose to file an affidavit of use, you should be filed together with evidence of use. In Cambodia, both, even you, if you file an affidavit of non-use, it is still sufficient to prevent any third party to file a cancellation based on non-use. This is a big difference between three countries. And next, I will talk about some difference between the trademark which we find under the marriage application and the national application.
Ms. Tweet, can you share your screen again? We can't see your screen. Sorry.
Excuse me, could you please loudly speak up? Speak up.
You stop share and share again.
Stop share. Okay.
Still okay? Guys, sorry for the technical glitch. So the governments of three countries have been actively promoting the protection of intellectual property rights in the three countries, especially trademarks. So if you were to export or import your products into the three countries, it is better to get them protected because they enforce a quite strict first to file basis. So who goes first, who get it first. So it is better to get them protected before you actually launch your products there. Your name and your brand is really important for your protection in the countries, not just Vietnam, Laos, and Cambodia. In fact, many other countries in the world have this kind of protection. Yeah. So Ms. Tweet, is it okay to share your screen now?
Yes, if you have any question about our topics, please let me know.
So what is the common ground of rejection over there? What is the common reason trademarks get rejected?
Common ground of refusal is based on absolute and relative ground. It may be refused based on the descriptive or common noun, or is if the trademark is refused based on the relative ground, it may be included. It is confusing, identical or confusingly similar with the prior registered or unregistered trademark application, and is identical or confusingly similar with the unregistered well-known trademark in Vietnam. There are a difference in Cambodia. The route of refusals is maybe on the requesting to disclaim the exclusive on the right in respect to any element in the mark. And the relative ground for refusals maybe includes if it is identical or confusingly similar to a trade name. And this is some common ground of refusals in all three countries.
So can I say the marks are commonly refused based on the reason that they are confusing or they are very similar to whatever that is existing and the famous marks, so they are refused?
Yes, understanding is correct.
So usually how strict is the examiner, like comparing Vietnam, Laos and Cambodia, which the examiners in which country is stricter?
Based on our experience and practice, I think that Vietnam is the examination in Vietnam is strictly.
Oh, those in Vietnam is stricter. Okay.
Since
so
there are,
Cambodia is relatively easy.
it is not. It's difficult to confirm the examination in Cambodia is very easy because now the examination in Cambodia also more strictly, but in comparison between three countries, Vietnam is the strictest.
Okay. So if they get refused, can you actually appeal, or can you meet the examiner to provide a reason?
Yes, it's possible to find an appeal or positions against the notification or decisions issued by the trademark office, and the examination of the examiner sometimes in Cambodia is easier than in Vietnam.
I see. But what about the language-wise? Marks from the foreign language, let's say English or Chinese, if they were to file into Vietnam, Laos, and Cambodia, do they have to translate or transliterate into a character?
In Vietnam, the letters not belong to Latin letters will be refused. For example, Korean character or Chinese character or Thai character should be belong to uncommon language, and it is not possible to register unless it's presented in strong stylizations as a Levi or has been widely used and recognized in Vietnam. But in Laos and Cambodia, the Chinese character or Korean characters or Thai characters are acceptable for register.
Oh.
It's required to be transliteration and translate in when you filing an application for this kind of trademark.
Oh. So for Laos and Cambodia, uncommon characters like Chinese and Korean, they are accepted. But Vietnam, you have to convert it to Latin AD.
In Vietnam, is not acceptable unless the trademarks in Chinese characters is presented in strong stylizations as a device or the good proof that it has been widely used and recognized by the Vietnamese consumer.
As they are famous. Yeah. So, but in all countries, they have to be translated and transliterated, right?
Yes. In Vietnam, instead of register a trademark in Chinese only, you could find the trademark based on its transliterations or its meaning.
Okay. So I heard about international registration of trademark called the Madrid system. So all of the countries, the 3 countries, they accept Madrid filing?
Yes. All 3 countries now, Vietnam and Cambodia, are accepted for filing an application through Madrid system. And as I presented, there are some advantages, and these advantages when you're filing an international trademark application and national application.
Mm-hmm.
If you file an application in through Madrid system, the fees will be lower and the time of examination will be shorter.
So do you get a lot of international registrations going in there?
Yes.
What about out, going out? Local going to international registration. Do you get a lot? So more coming out or going in?
National application will is more expensive than international trademark applications.
Oh, okay.
Yeah.
More of a national entity.
It takes a long time to exam.
Okay.
Yeah.
All right. What last question, what about marks that cannot be registered there? Is there any difference between the 3 countries? Marks that cannot be registered.
The trademark when we cannot register if is contrary with the public order or morality of good customs. Yeah, there are. If I mean, it belongs to absolute ground and relative ground, as I presented before.
Mm-hmm.
Yeah.
Oh, in Malaysia, marks that consist of the national flower. Our national flower is hibiscus. Our flag, the national emblem, the Red Cross. Those are not registrable in Malaysia. What about over there? Do you have the same thing?
Same in Vietnam and Laos and Cambodia. If it's contrary to public order or morality of good customs,
okay.
it will not be accepted as a trademark.
I see. Okay. Do you have anything to share with us? Anything else to share with us?
I will share to you about the use of the TM symbol and R symbol in the trademark.
Oh, nice. I think many of them don't. Do you want to share your screen, or you are just gonna?
No, I will talk
Oh,
very
just,
briefly.
okay.
Yeah. In Vietnam and Laos, if you file a trademark with the TM symbol, it's impossible to file at the time filing. But in Cambodia, if the trademark containing the R symbol, it should be removed at the time of filing. If you do not remove this this symbol, it will be refused for protection. In Vietnam, the use of the R symbol, in case it has not been registered in the trademark office, it will be considered as a fraud indication. Fraud indication.
So they cannot use the R symbol if they have not been registered.
Yeah, it's in case a trademark has not been registered by the IPVN, when you use in practice, it will be considered as a fraud indication. In for the
TM, can I use it? What about TM? Can I use it if I don't register?
Yes.
Yes. Okay.
The TM symbol, it should be displayed by the IPVN, but in Cambodia, you should display at the time filing in order to avoid any possible operation from the office.
Okay, I see.
I will say some practice about the.
I can't hear you.
Here. Some. I would like to talk about the appeal against a refusal in Vietnam, Laos, and Cambodia. For example, the appeal in case a trademark is refused for protection in Vietnam, you have only one extension of time, and but in Laos it is cannot extendable the extension of time. Meanwhile, in Cambodia, you have 3 times for extension.
Oh.
Yeah. The chairman office exam, and in case they did not accept with the response, in Vietnam they will issue a decision on refusal, but in Cambodia the TIV will issue a further notification of provisional refusal, and there are maybe three notifications of provisional refusal instead of a decision on final refusal. And in case your trademark is identical or confusingly similar with a prior trademark, when you file a response, a supporting document maybe is a letter consent from the owner of the prior trademark. In practice, Laos and Cambodia almost accepts this kind of supporting document, but in Vietnam, it depends on case by case. This means that the IPPN may be not accept the letter consent from the owners of the prior trademark, since they think that the trademark is still confusingly similar to the public. Once public, when the product during the trademark is sold on the market. Meanwhile, it's usually in Cambodia and Laos, almost the letter consent are acceptable.
You mean evidence of use of the mark, is it?
Yes, when the mark is refused, this kind of supporting document to outcome the refusal from the trademark office.
I see. So meaning if a mark is confusingly similar, so for Laos and Cambodia, you can submit the evidence of using this mark.
The examination in Laos and Cambodia is easier than the Vietnam.
But Vietnam is harder to overcome.
Yes. What about Malaysia? What about in Malaysia?
Malaysia also, we have the chance to submit this type of evidence because we practice common law, right? So, but still, it is also case by case, depending on how confusingly similar it is. Yeah.
Yeah, in Malaysia, the rules of disclaimer is applied or not?
Yes, yes, we have to disclaim. We have to disclaim terms that are descriptive or similar. Yeah. Yep. So that's it. Any questions from the floor? Let me check our Facebook. Is there any question? Okay, no question.
If you have any questions, I can, but
Yeah.
I can see you later. I can
No more
reply you.
Okay. More questions from the Zoom and from the Facebook. So thank you very much to Ms. Thuy for giving us a really nice sharing about the trademark system in Vietnam, Laos, and Cambodia. So if there is any question, you can actually refer to us, NBSMY, by dropping us a message on Facebook or by going to our website, www.mbs.com.my, and drop us an inquiry there. Coming up next on our mini MiniPTALK tour, we have to talk about industrial design. So it will be delivered by our patent agent from NBS Flag Tour. We'll talk about industrial design protection of fashion designs. Yeah, so I think a lot of ladies designer bags and so on, jewelries. Yeah, so it will be conducted on the 10th of December. It's a Thursday, same time, 11 a.m. Yeah, so you can register to our Zoom on this MiniPTALK Design View, this link. All right. So if you have any queries and to follow our page and news, you can scan this QR code. This QR code will lead you to our Facebook page or our official website, www.mbs.com.my. Yeah. So thank you very much for attending our talk this morning. And also thank you to our speaker, Ms. Thuy from Ageless IP. Yeah. See you soon. Bye and thank you. Have a nice weekend.